May it please the Court, before the short adjournment, Lord Mance asked me for the specific provisions I was relying on in relation to rights of appeal.
Well, I thought it was in claiming compensation, actually.
Claiming compensation, yeah. But, my lords, in relation to that. We have two answers, one of which is under the directive, one of which is under Portuguese law. The Portuguese law state will be less satisfactory, but I'll try and do my best to explain to your lordships. Under the directive, I realise, reading the transcript quickly over the short adjournment, that in my attempt to park on one side crisis prevention measures, I may inadvertently have misled the Court as to the effect of Article 85. Can I invite the Court's attention to Authorities Volume 1, Tab 2, page 1261.
Right, yes, definitions.
And I gave the Court the definition of crisis prevention measure under Article 101 and said that didn't include the resolution tools, which is correct. What I didn't read out to your lordships, and perhaps should have done in order to make the distinction clear, is the definition in Article 102, crisis management measure, which means a resolution action. It is then, I'm afraid, necessary to turn back to page 1256 to definition 40. Resolution action means, at the end of the second line, the application of the resolution tool or the execution of, or the exercise of one or more of the resolution powers.
So definition 40, did you say?
Definition 40 on page 1256.
Oh, right.
I'm sorry.
Right.
So resolution action includes the application of the resolution tool or the exercise or one or more of the resolution powers. And that means that crisis management measure includes the exercise of the resolution tools and powers. And if I can then invite the Court to go back where I started, which was Article 85, which is on page 1352.
The paragraph 40 definition applies to institutions or entities referred to in point B, C, or D of Article 1.1, not institutions in point A, which is institutions established in the Union. I'm not sure.
Where the financial institution is a subsidiary of a credit institution or investment firm.
Yes. But does that definition apply to institutions established in the Union?
It's a disjunctive or. The decision to place an institution or entity referred to in B, C, or D under resolution pursuant to Articles 32 or 33.
I see.
Or the application of resolution pool.
Yes. So yes, it's the disjunctive you rely on. Yeah.
Yes.
Okay. Thank you,
Lord. Yes.
Sorry.
And that brings us back to Article 8.
It must. Yes, I see. Yes, I see. Yes.
Yeah.
Yeah.
Yeah. Sub 2 is concerned with price.
Subsequent.
Sub 3 and 4 are both management.
Yeah.
Lord Sumption's there ahead of me. I'm grateful.
Mm-hmm. So where do we get the it's right at the end of 4, isn't it?
It's at the end, my Lord. Well, it's 4 on which I rely, because 3 is reference to crisis management matters, a right of appeal. Right of appeal subject to no automatic suspension, decision immediately enforceable, rebuttable presumption, suspension against the public interest, and then annulled decisions, remedies for a wrongful decision shall be limited to compensation for the loss suffered.
Right.
So that's the position under the directive.
So that's the directive, and you say there's something under Portuguese law as well.
My Lord, the position under Portuguese law, I have to start by saying, is not addressed in the expert evidence.
Well, then perhaps we better keep away from it.
My Lord, if I can simply give your Lordship the references to what we do have in the bundles. In Core Volume 3, tab 33, there is the Credit Institution of Financial Companies Legal Framework, and Article 12 contemplates the lodging of appeals. That's page 677. And at page 872, Article 145N, subparagraph 4, provides for BDP on public interest to determine compensation as opposed to annulling the decision or accepting the annulment of the decision. But, my Lord, it's not explored in the expert evidence under Portuguese law, so I can't take the matter any further than simply to say there are those provisions which are in the materials that were before the court at each stage.
Right.
My Lord, I was making those points really as part of the simple point that the idea that the safeguards contained in the EBRRD should be policed not by the courts of the home member state, but by enforcing courts to see whether they have been applied, runs counter to the structure and spirit of the directive. And the point that, Millennium friend Mr. Lord's point that the counterparty will of the wisp is wrong. The liability is not courtless because it is determined by the December decision. That tells them where to go, which is the BESH. And to the extent that they object to it, they have remedies under administrative law or the law of the home member state.
Yep.
And which ought to implement Article 85.4 and to provide for compensation.
Right.
I don't have to say it does. It's merely enough for the directive purposes that it ought to. But there are, as I say, provisions which on their face appear to. Now, against that background, I will, if I may, turn to our principal argument and just say a couple of things about that. I'm not going to repeat my learned friend Mr. Howard's argument. Our principal argument is a very simple one. I confess I am less subtle than my learned friend Mr. Rabinovitz or my learned friend Mr. Lord. It seemed to me that the combination of my submission, rather, is that the combination of point 4 of the agreed propositions, where an administrative act which is not a nullity defines a party's rights and obligations, it is directive effective, and the party's rights or obligations under Portuguese law are as stated, unless until such a decision is annulled, means that the paragraphs A and B of the operative part of the December 2014 decision mean that BES's liability towards Oak Finance pursuant to the loan agreement was not transferred. The decision is effective as of the 3rd of August. Now, there was clearly a debate between the experts as to the precise nature of the decision as a matter of Portuguese law. But the court will recollect that you have been shown the power which BESH thought it was exercising. BESH says it is exercising BDP thought it was exercising. BDP says it is exercising the powers under the Banking Act to transfer and makes reference to the exclusions under the Banking Act of what is it entitled to transfer. It is saying it is exercising a power as resolution authority, and that is directly effective, according to its terms, binding all the parties who are currently before this court. That is We say, therefore, whatever the position may be as a matter of precise analysis under Portuguese administrative law of the technical nature of it, how Portuguese law stands now, and how Portuguese law stood at the moment when these proceedings were begun. And I'll come back to that when I'm dealing with our alternative cases too, because I will at that point be saying that there couldn't be a clearer example of a resolution authority exercising resolution powers. It is a power to delimit what has been transferred, to decide what has been transferred and what has not been transferred. Can I now deal briefly with the contrary arguments relied upon by the appellants? Their first contention is that the December 2014 decision was a decision of an administrative authority, which they say is merely provisional in the sense that it can be annulled and was not a final judgment. That's the first part of their submission. They go on then to submit that it is likely to be annulled, and I'll deal with that in a moment. But we say that first part of that submission takes the appellant's case nowhere. As we say in paragraph 65 of our own case, there are 4 answers to it. First of all, any administrative act by a resolution authority is potentially the subject of legal challenge. The test for recognition under statutes requiring for the recognition of foreign judgments often require that they are the final word on the matter, time for appeal is expired and the like. There is nothing like that in the reorganisation directive or the EBRRD. On the contrary, the EBRRD says, for very good practical reasons, that the decisions of the administrative authority shall be immediately effective, so that the process of resolution can be got on with. As I say, my second point, the philosophy of the EBRRD is that decisions taken by the resolution authority are the right decisions. It's not the decisions of the court, not the actions of a court, that the EBRRD is concerned with. In that respect, there is a distinction between the reorganisation directive, which refers to the actions of the judicial or administrative authorities, and the administrative or judicial authorities, and the EBRRD, which refers to the actions of a resolution authority, which has to be a public administrative authority or authorities operating public administrative powers. The reasons for that are stated in the recitals. They're all set out in our case. Reasons of speed, expertise, and because it is an ongoing process, you can't keep coming back to courts. In this country, it is possible for the courts to move very rapidly, sometimes supervising the activities of receivers and the like, but that may not be the case throughout the European Union. So, for reasons of speed, they have tried to keep these decisions out of the court so that you can have a practical process which is not held up by litigation. Thirdly, although the EBRRD requires the courts to be able to review the decisions of the resolution authority, it indicates, as I've shown the court, a strong presumption the decisions should continue to operate, and those aggrieved left their financial remedies. And fourthly, the courts that should conduct that review are the courts of the relevant home member state, not those of the other member states of the EU. This brings me to the appellants, the second limb of this argument on the part of the appellants, based on the submission that it was found by Mr. Justice Hamlin that they have much the better of the argument that the oak liability was not an excluded liability, and therefore they say this court should act on the basis that the decision of the Bank of Portugal is liable to be overturned. Now, I, of course, represent the recipient of the decision as opposed to the party who took it. The learned friend Mr. Howard represents the Bank of Portugal, so it is not my job to defend the decision of the Bank of Portugal. But what I do say is this. The consequence of the idea that it should be incumbent upon those who seek to uphold the decisions of a resolution authority, such as the December decision, in every country of the Union, member state of the Union, in which those decisions come to be enforced, that they have to put before the court of that member state evidence that shows that they, not the other side, have the better of the argument that the decision was correct, only has to be stated to be shown how impossible that is. For a start, the people who want to rely upon the decisions may well not, as we are not, be the Bank of Portugal. We will not have the evidence, but we are bound by the decision.
Well, supposing there hadn't been a December decision, supposing someone had just sued you on the basis of the August decision, you'd be in exactly the same position.
Well, Lord, no. In those circumstances, we would have to raise the issue if there was an issue and would be stuck by it. But at the moment, we have a decision which binds us. But it is said that in order to show that the decision which binds us in Portugal, and which we are obliged in Portugal to act in accordance with, to show that that actually represents the law, even though in Portugal it also binds the appellants, we have to put in front of the English court evidence which positively shows that the decision is right, in order to show that we have the better of the argument. In other words, that the English court prima facie has to evaluate the correctness of the decision. Now,
I don't know whether this has ever happened before, but in other words, that the bankers of Portugal has had to interpret its the operation of its previous decisions, but the articles they relied on don't seem to deal with that or give such a power in terms at all. It's a slightly curious position because nobody can agree actually what the effect of the December decision was, what it's doing. And until you decide what it was doing, it's quite difficult to say under what power it can have been done or whether there was power to do it. But all that seems to be common ground, that this is binding and whatever it's doing, it's pursuant to some power, even though on the face of it the articles relied on don't contain such a power.
Well, my Lord, we say it was possible at the stage before Mr. Justice Hamlin, we did toy with the idea of having cross-examination of the experts and things like that.
Yes.
But it seemed to us that since all of the experts agreed that it was an administrative decision, no one sought to argue that it was void, and as an administration it defined the rights of the parties. And Your Lordship has agreed proposition 4 there.
Yeah.
Which still appears in the statement of facts and issues as an agreed proposition.
No. So that's it. Right.
One didn't need to resolve that in order for me to be able to make my submission that currently represents the law of Portugal. No. And as for what it decides, it would be for somebody else, we would submit, to say that it decides something other than that which it says on its face. I mean, if one wants to know what the decision decides, one reads it, and it's unequivocal. It decides there was no transfer and that is retrospective. So that's the foundation of that submission. As we say, it cannot be right under the structure of the directive, or indeed as a matter of practicalities, that when one's looking at a decision of the Bank of Portugal like that, in order to say it's right, we have positively to assert its correctness and adduce evidence and invite this court to adjudicate on a matter which is primarily for the courts of Portugal, which will take, I suspect, entirely different considerations into account if the claims, the details of which are before the court in the Portuguese proceedings are anything to go by, where they raise lots of issues other than the purely factual.
Right, you're going to deal...
Lord, I was going to go on with the question of whether it was bound to be set aside. And on that, I was going to segue into the guaranteed trust argument very briefly. Can I start just by making clear our position on this? We adopt Mr. Howard's submission that this is not a matter which is open to the appellants on their grounds of appeal at present, And despite the confident assertion to the contrary by my learned friend Mr. Rubinovitz, it's plain, we say, if you read the grounds of appeal and the supporting explanation of them, that that's not what they were saying. And it's undoubtedly not something that they have ever said before at any stage. Now, my learned friend Mr. Rubinovitz has made a fair amount of what I said before Mr. Justice Hamblin, and has rightly said that I failed in front of Mr. Justice Hamblin to lay stress upon the Reorganisation Directive Article 3 and upon the obligation under that to give it the effect that it had throughout the Union, as it has in the home member state. And he's right about that. But can I just invite the Court's attention to what I did actually say? Because certainly I squarely raised, albeit by other routes, the points that we are now making. If the Court could take the supplemental volume and look within it at tab 15, here is my skeleton argument before Mr. Justice Hamlin. And if I can just invite the Court to turn up page 4157 and look at paragraphs 12.1 and 12.2. I won't read them out.
Sorry, Mr. Salter, can you give me the reference again, please?
I'm sorry, my Lord. It's the supplemental volume,
Yes,
tab 15,
yes.
and it's at page 4157.
Thank you.
I can just invite the Court to look at that.
So you're saying 12.1
12.1 and 12.2.
is in effect what Article 3 achieves,
My Lord, yes,
if you didn't refer to it.
absolutely. And, my Lords, just for completeness, the way I put the case can be seen from the transcript of my reply, which is at tab 18 in the same volume.
Yep.
And just for shortness, if I can invite the Court's attention on page 4262 to page 113 of the directive, of the transcript, which is in the top left-hand corner. Can I invite the Court to read from line 9 of that to line 1 of the following page? May I offer one translation that in line 16, when I say Article 5...
It's regulation.
Sorry, my Lord.
It's meant to be regulation.
Regulation 5.
It's
Article
Regulation
3.
5, absolutely.
Yeah.
Sorry. I'd said Regulation 5 at page 109 when I was opening it, and I'm afraid I misspoke. And that, in a nutshell, was the case I put in front of Mr. Justice Hamlin.
Right, well, all right, that's the...
And on that basis, we say the submissions, as Mr. Justice Hamlin recorded, was that on the other side was that Portuguese law was irrelevant. And certainly, therefore, it wasn't raised as a matter where the experts were encouraged to explore what would be the position were, in fact, the Bank of Portugal's decision to be erroneous, what the remedies would be. And certainly they didn't have the benefit when they were prepared. Our expert is the only one who mentions it. The experts on the other side don't mention the possibility. We say fairly read. Our expert actually isn't as unequivocal as is suggested by learned friend Mr. Rubinovitz. The agreed propositions say no more than may be annulled. And I've given your lordships the reference to the provisions which suggest that on public interest the Bank of Portugal may say that the appropriate remedy is compensation rather than annulment, as would make sense under Article 85.4, because one is talking about things which will have moved on.
Yeah.
And it's not me that has, for the purposes of this argument, we say, to show that there is not going to be an annulment. All we say is this court can't safely work on the basis that the decision is going to be annulled, even if this court were to take the view that it was open to give the appellants permission to amend their grounds of appeal in circumstances in which the matter is wholly unexplored, except as a sort of passing reference in the expert evidence at the time, and no one has directed argument to it, so this court doesn't have the benefit of the analysis of any lower court. As to the merits of the guarantee trust argument, I adopt my learned friend Mr. Howard's submissions. There's no proper analogy to be drawn between the exercise of adjudicating upon the rights conferred by a foreign contract and the exercise of giving effect to the decision of the resolution authority of a member state. Different processes require a different approach and different results. And generally, we say, the spirit of the EU legislation here requires the recognition of decisions, not their minute scrutiny. The scrutiny of decisions is a matter for the courts of the home member state. The next point that is made against me is the retrospectivity argument. And we say, well, the question here is the effect of the decision under Portuguese law. If under Portuguese law it is retrospective, then as a matter of principle it ought to be treated under English law as retrospective. And we say there is no reason in EU law why reorganisation measures should not be retroactive if that's their effect under the law of the home member state, and we rely on Kepler. The coach and horses argument. There are two limbs to this, both equally misconceived in our submission. The first seems to be the suggestion that administrative authorities ought not to be able to make binding decisions which actually change people's rights and which are then acted on. That, we say, is entirely contrary to the mechanics of the EBRD. The second is the ideal that it will undermine the detail of the EBRD and the qualifications placed upon the powers. We say this misunderstands the structure of the directive and the EU law context as a whole. It's a minimum harmonisation directive. What it's intended to do is to give a minimum toolkit so that every member state has it in order for the protection overall of...
which directive is intended to give a minimum toolkit?
EBRD.
The
The EBRD. I'm sorry, my lord.
No, that's right.
Forgive me.
I think you did say EBRD.
I should be more specific.
Right.
It's plainly a minimum harmonisation directive. It says so in a number of places. It's intended to give a minimum common level of powers, but it's quite express about the, as we say in our case, about the ability of member states to give more powers, and these are all built into the structure of the home member states' laws. There is no attempt to harmonise the laws of the member states as a whole, any more than there was an attempt under the reorganisation directive to harmonise their laws as a whole, merely to give full faith and credit to the legal system of each member state and require the recognition of what's done under it in those particular circumstances elsewhere. We also, as I've submitted before, say that there are provisions in the directive and elsewhere for compensation, the equivalent in the local law of Frankovich damages for failing to give effect to European rights. Well, just one example of that, perhaps, is the Article 73 safeguard. It's quite impossible that the Article 73 safeguard, which is a safeguard about the writing down of shares and things like that, could be interpreted as in some way conditional upon providing a condition for the mutual recognition of such actions elsewhere. Can only possibly be applied in the member state. We do, however, accept that there is some threshold or perimeter tests of mutual effect. I'm not suggesting, not submitting to the court, that if the gas board or the water board of Portugal decided outside its powers that it was going to make some decision about an exercise by the resolution authority of an earlier power, that would have to be given recognition. But that, of course, would be a case in which almost certainly the decision of the gas board or the waterworks or whatever was void, because it would have no power to deal with the matter. We are a very, very long way from any difficult perimeter questions. I come back to the point that this is a decision by a central bank acting in a resolution matter, purportedly invoking powers under the Banking Act to do with resolution, making a formal administrative decision about which liabilities do or do not pass to the bridge bank under the bridge institution tool. We say it doesn't get much more central, whether viewed as an ongoing reorganisation measure or a discrete resolution tool, than that.
What further points have you got to deal with? Because I have a feeling there's a considerable area which you haven't yet touched on, and you've got 25 minutes.
Well, Lord, indeed. I was going to go quite quickly. That brings me to our three further points.
Yes, which relate
our alternative case.
Issue 2,
as it were.
whichever addresses Issue 1 by Mr. Rabinovitz.
Yeah, absolutely. Issue 1. I've dealt at somewhat greater length with the framework of the directive and with our primary case, because not merely because that is a primary case, but it gives the background to what I've got to say on these three subsequent matters. The first of our submissions is that the December decision was the application of the resolution tools and the exercise of the resolution measures. And I can't put that submission higher than I have just stated to the court, that this is the resolution authority, the central bank, dealing with an institution under resolution and making a decision purportedly pursuant to those banking powers, which is a formal administrative law act defining what has been and what has not been transferred to the bridge institution. We say that's before one even gets into argument about transfer or examination of powers. It is part and parcel, as it were, of the exercise of using the bridge institution tool. Because the bridge institution tool is a tool. It is not an ability to make a single transfer. It's an ability to assist in the resolution of a distressed institution by doing a variety of things as part of the process of resolving that institution. And part of that process means making perimeter decisions as to what is in and what is out. Bank of Portugal, in fact, did that. The court was shown this morning the large number of decisions that it made, not merely in relation to this liability, but in relation, in the later August decisions, to other liabilities where there was uncertainty as to whether they were in or out, in relation to bond liabilities, which are the subject themselves of a whole other series of challenges before the Portuguese administrative courts. It's an ongoing process. I come back to my point about this being a process. And so we say it's an exercise of the tool. It is an ongoing exercise of the bridge institution tool. And if that doesn't attract the court, I can't take that submission further. But we say it is a perfectly sane and sensible interpretation, and one which is consonant with the general practical spirit and intent of the directive.
Well, do you have to bring yourself within Article 40 to operate this argument? Article 40 is gives
Lord,
power
yes.
to transfer.
Yes, I was
and
just-
it gives power to transfer back, provided the conditions laid down in paragraph 7 are met. And we know what they are. But
My Lord, I've got... that's our second alternative case, that the December 2014 decision should itself be recognised as a transfer within Article 40. This first case is that it's not necessary for me to bring myself specifically within the transfer provisions of Article 40.
that turns on what? The fact that the powers are only, what in particular powers, just remind me where that provision is. They're not exhaustive, is that right?
My Lord, yes, they're not exhausted. We go back to the beginning of the resolution section. Court will permit me. I don't want early intervention, I want resolution. Sorry? Article 37, yeah. Yeah. It's Article 37.
Right.
Yes, my Lord, before I go to Article 37, can I go to the recitals again, 1233? I say, I make no apology for always starting with the recitals before I go to the operative provisions. And recital 10, I'm sorry, perhaps I will start with the recital 9. Some member states have already enacted legislative changes. And then the last three lines, starting halfway down. Effective resolution regimes in all member states are necessary to ensure that institutions cannot be restricted in the exercise of the internal market rights of establishment by the financial capacity of their home member state to manage their failure. These obstacles should be eliminated. Rules should be adopted in order to ensure that the internal market provisions are not undermined. To that end, rules governing the resolution of institutions should be made subject to common minimum harmonisation rules. So the idea is that they are and then recital 44 where an institution is failing or likely to fail, national resolution authorities should have at their disposal a minimum harmonised set of resolution tools and powers, etc., etc. Member states should be able to confer on the resolution authorities powers and tools in addition to them conferred on under this directive. The use of these additional tools and powers should be consistent with the resolution principles and objectives. In particular, the use of such tools or powers shouldn't impinge on the effective resolution of cross-border groups. So we can see it's part of the purpose of this, as I submitted to the court in outline, that this is there to provide a minimum toolkit that everyone can have in order to ensure that in every member state any failing financial institution can be resolved. But it doesn't stop the member states having more. Some states, UK for example, started with the Banking Act 2009 and had already gone a long way down the line. Portugal had resolution powers in advance of the coming into force of the EBRRD, because in fact it exercised them in this particular case. So it's not stopping that, it's just saying for safety we have to have this minimum set. And then that takes me back to the directive, the operative provisions. And Article 37. General principles of resolution tools. Number one, member states shall ensure that resolution authorities have the necessary powers to apply the resolution tools to institutions and entities that meet the applicable conditions. So just generally, they may have.
And then the power to give additional tools and powers under 9, yes.
Yes, Lord.
And you would say what, the general administrative power is an additional tool?
Oh, absolutely.
Yeah.
And so, exercising administrative law powers in the context of resolution is the exercise of resolution tools and powers. And it's, as I said, as short as that. My second point, and I will finish by 3, I promised the Court, as I have promised my learned friend, Mr. Rabinowitz, is that the December decision was a transfer. Of course, our primary case is that this is the wrong question. But we say that it was a transfer in this sense, that it is illogical to distinguish between liability A was not within the class of assets transferred. So, though it was not transferred, we retransfer it back to the original debtor. And liability was not within the class of assets transferred, so it was not transferred and must be treated as not transferred. And we say, in the present case, we can bring ourselves quite squarely within Article 47 as a transfer, on the basis that, as the Court has seen, Article 47, it's on page 1304, gives power to resolution authorities to transfer shares or other instruments of ownership back in 2 circumstances. One, the possibility that the shares or other instruments of ownership, assets, rights and liabilities is stated expressly in the instrument which the transfer was made. The Court has seen the statement. The objection is that we didn't specify the particular shares. We say that's not borne out by the other language versions of the directive, and the Court has the original languages there, and I'm sure can make its own mind up as to whether that's a good point or a bad point. But at least in some languages, there is no equivalent word to the word specified. And also, of course, it would make no practical sense to require one to be specific about assets, where one is likely, at the beginning of the bridge bank, to be transferring by classes in large numbers with no time to make any investigations. How can you specify what in those classes, the composition of which you may not know at that point is the bridge bank, you're going to retransfer? Of course you must be able to say, well, we transfer these classes, but we reserve the right to transfer it back once we've made our inquiries. And that's precisely what Bank of Portugal did. So we say it plainly came within 7A, and it also thought that it came within 7B. Now, 7B says the specific shares did not in fact fall within the classes or meet the conditions for transfer specified in the instrument by which the transfer was made. The natural reading of that is to produce what, if one is excessively literal about it, is a paradox, that it doesn't fall within the class that you've transferred, therefore it wasn't in fact transferred, but you may transfer it back. We say there is in truth no paradox. You can say this shouldn't have been transferred, it didn't fall within the class, so for the avoidance of doubt we are transferring it back. And we say that in effect, to the extent necessary, that is what Bank of Portugal did. Of course, in Portugal, Bank of Portugal's case, like my client's case, is that there was no transfer. Bank of Portugal says that it's right, that in fact this was an excluded liability. But there's nothing illogical or contradictory about saying, well, if I was wrong about that, then I need certainty, so I transfer it back. They have in fact expressly done so in September. But as my Lord Sumption said, either it defines the liabilities or it transfers it. There is no way that this can have been transferred. We said it has not been transferred unless the practical effect of it is to transfer back. And it isn't an answer to say, well, I can envisage a strained construction in which there has been some specific transfer. That doesn't appear to be what B is dealing with, nor is it consonant with the fact that A is plainly dealing with matters that are transferred by classes and where we're dealing with individual institutions which are likely, because you will only get here if you have a systemically important financial institution, are likely to be possessed of a very large number of assets, liabilities and things like that, that can only be dealt with in bulk.
Would this be available, Article 47, in respect of a decision which was avowedly conditional upon the factual basis underlying it being upheld or being correct? I mean, it's the idea of transfer under 41 and retransfer under 47 seems to look primarily, at least, to outright transfers and retransfers, whereas the retransfer here was done by administrative decision, but by implication was subject to the original August criteria and liable to be set aside if the criteria of excluded debt were not met.
Lord, I would say that that starts from the wrong place. It is true that Bank of Portugal acknowledged, as it was bound to acknowledge, like that any other administrative decision, it was susceptible to challenge. After all, first instance judicial decision could have been appealed, but it could have been challenged. But the point about administrative decisions made for the purposes of resolution under this is that they are immediately effective. Yeah. The point is that that defines the position going forward, so that you can get on with the process of resolving, so that you can stop the financial institution falling down. It makes a very big difference to a financial institution whether it has to have the money to pay out the kind of coupon which would be payable on an $862 million loan on a regular basis. It makes a considerable difference to its ability to operate, the amount of capital it has to hold, the number of staff that it can fund, the breadth of its operations. If it's funding that, it can't afford to keep branches open in other places. I'm speculating here, but I mean, it's the kind of common sense answer which produces, I don't know the precise facts, but it's the kind of thing which illustrates why the decisions of resolution authorities should be immediately effective. As we say this one was, and it's common grounds matter of Portuguese law, it was. And therefore, it was a decision which, for the practical purposes of the resolution, defined the position as between the parties.
Well, the decision was absolute. The ground for the decision was what they believed was a well-founded belief based on evidence. And that the statement that was the ground of their decision could itself be challenged like any other reason given for a decision.
Absolutely.
So it's not peculiarly provisional,
no.
this particular decision.
My Lord, absolutely. It doesn't say on its face this is provisional. It says this is the decision.
Yeah. And this is why we've taken the decision.
Yes, absolutely.
As with any decision, reasoned decision, if the reasons are undermined, that may be a ground for annulment.
My Lord, indeed. And this one has come under such sharp focus because it's not liked by the claimants, the appellants in this case, because it deprives them of the right to go against Novo Banco rather than against the insolvent Besh. But actually, of course, it would be true not merely of all administrative decisions, but of all decisions made by a resolution authority. Because any one of those will be made on a series of factual assumptions, a prediction possibly as to the future, a look back as to what the assets and liabilities are. It will involve an exercise of judgment of some kind. All of those are potentially, theoretically, capable of challenge. It doesn't make any of them provisional. And we are getting, I submit, the appellants are getting hung up on the idea that this is in some way provisional because they have a right of challenge and because we said, the Bank of Portugal said it is made on the basis of our conclusion as to the facts, and of course that conclusion may turn out to be erroneous if further evidence is put before a court in due course.
Right?
Lord, our final point, and I will finish in 5 minutes, is really quite a short one. It's the point that my letter from Mr. Rubinovitz refers to as the untransfer. And it can be described very shortly. It's another way, if you like, of putting our primary argument, but it was actually the way I put it in front of Mr. Justice Hamblin, that if we're right about the legal effect of BDP's December decision, then there was, the effect of the August decision is that there is no transfer. Because as a matter of Portuguese law, there is no transfer. And so giving effect to the August decision, its effect under Portuguese law is that there is no transfer. And one can say that that has effect under English law by virtue of the obligation of the English court to recognise the transfer made in the August decision according to its effect under Portuguese law. And its effect under Portuguese law is, as I said to Mr. Justice Hamblin, that there was no transfer. That was the position under Portuguese law at the time.
This was the other issue, really.
Well, my lord, it's
Two seem to have joined together here.
In my end is my beginning, my lord. But it was the way I to misquote the poet. But the fact is that that's the way I put the case in front of Mr. Justice Hamblin. That the effect of the August decision was not that there was a transfer, but that there was not a transfer. That's what the BDP's decision said. And it's impossible to give effect to the August transfer in circumstances in which it has been said, as from the 3rd of August, there was no transfer. You're not giving effect to something that exists. It no longer has an existence to give effect to.
Yeah.
And it's another way of putting the point.
Thank you.
Lords, I've got 5 more minutes. Would your Lordship just allow me to ask my junior and my solicitors whether there is anything more I need to say?
Of course.
I'm grateful. Milena Junior rightly reminds me to remind the Court of a point made by Milena's friend Mr. Howard earlier, that of course it's as relevant to this submission as it was to the primary submission, that by the time the English court came to, by the time the transfer provisions came part of English law in January 2015, there had been no transfer. Up to that point, the recognition provisions in English law provided only for recognition of reorganisation measures, that is, measures to uphold the financial standing of distressed institutions. Now, this is not an argument that it couldn't be recognised in English law. Quite aside from anything else, one of our primary arguments is that we should recognise this as a reorganisation measure itself, because for reasons that my learned friend Mr. Howard explained, simply as a measure to help manage a distressed financial institution and preserve its business, it qualifies as a reorganisation measure. It also qualifies as a reorganisation measure on the basis that it is helping to stave off and ensure an orderly liquidation of the financial institution. So we don't say that's there. But the point at which it qualifies as a transfer is the point at which the amendment to the 2004 regulations was made by the 2014 regulations. And that occurs in January 2015, after the point at which it had been determined that there had been no transfer. So the point at which this comes to be recognised as a transfer under Article 66 there is no transfer. Unless there are any points on which I can assist the court, those are my submissions.
Are there any more points on which you wish to assist the court, Ms. Phillips? Thank you. Yes.
There are some on which I'd like to assist the court, if I may. Just going back to the beginning and reiterating the structure in which this debate is taking place. As the court will recall, we're dealing with an English contract. We're dealing with rights and obligations under that English contract. It follows, therefore, and I think this is common ground, that decisions of Portuguese authorities, even Portuguese banking authorities, have no effect on that contract unless they can bring themselves within the various directives and regulations to which I took you in the beginning. And there are two ways in which they may do that, either under the Resolution Directive or under the EBRD. They can either do that by establishing their resolution measure, or by establishing, if not a resolution measure, then they are the manner in which the Portuguese law implements or applies the earlier resolution measure. And I've described those as issue 1 and issue 2. It doesn't really matter. Just before I develop my submissions, I think there was a suggestion made indeed by both my learned friends that you're not dealing here with harmonisation directives. With respect, whilst that is true of the reorganisation directive, it is not true, I'm sorry, I'm doing it again, it is not true of the EBRD. And if the court wishes not now, but in due course, to look in particular at recitals 4 and 10 of the EBRD, that makes it perfectly clear that it is a harmonisation measure. Now, coming back to the general structure, it follows that if my learned friends cannot bring the December decision within either the category of resolution measures, properly so called, or as the way in which Portuguese law implements or affects the earlier resolution measure, that's to say the August decision, it is irrelevant. It is irrelevant whether or not any aspect of Portuguese law was a part of Portuguese law, whether made by the Bank of Portugal, or indeed by the gas minister, or indeed by the foreign minister. Just to take an example, if you had the gas person or the Portuguese foreign minister, or a local authority or any other authority, saying something which was binding as a matter of Portuguese administrative law, that the oath liability had not been transferred. With respect, that would be completely irrelevant to the contract with which we're dealing, because it's neither a resolution measure, nor is it a measure by which Portuguese law gives effect to the August decision. And with respect to my learned friends, we have had continually sliding from one to the other, talking about Portuguese law as opposed to focusing on whether they can come within one of those two categories. Now, in terms of the first category, was this a resolution measure? What I called issue 1, everyone else has dealt with it as issue 2. Can they come within one of the three gateways? Was it intended to preserve or restore? Was it a transfer? Or was it a power or a tool? I don't propose to say very much about that. Safe to say, if you look at the December decision itself, you will see that the power they're exercising is not a power to retransfer. It refers to the Portuguese Banking Act, but the provision that it refers to, and this is all set out in Mr. Justice Hamlin at page 428 and 429, it's to an earlier provision. It is not to the retransfer provision. It was also suggested by my learned friend, Mr. Salter, I think for the first time, that this may be a power, a resolution power, albeit not one identified in the EBRD. And I think effectively he said, because it was a power which was exercised by the Bank of Portugal, that meant that it was a resolution power. With respect, he has no basis at all for saying that. That is simply assertion, and it's assertion made up for the first time. Nothing suggests, there's no area of Portuguese law which identifies what the Bank of Portugal did in December as being the exercise of a resolution power. That is not true of the August decision. The exercise of a resolution power. That is true of the August decision, but completely unsupported by anything in relation to the December decision. Now, that's what I was going to say about the issue, what I've called issue 1, were these resolution, do these come within reorganisation measures? I do want to focus on issue, what I've called issue 2. That's to say whether it is right to say of the December decision that the December decision was the implementation or application of the August decision as a matter of Portuguese law. And I have in mind, of course, and the tribunal will have in, sorry, the Supreme Court, the court will have in mind that we're dealing here with Article 3, and it is common ground now, I think, that what my learned friend has to establish for the purposes of bringing the December decision within Article 3 is that the December decision constituted a law, regulation, or procedure applicable in the home member state by which the August decision was implemented or applied. Now, that necessarily, as I said when I opened the case, makes one ask, what is the Portuguese law effect of the August decision? And our general point, as the court knows, in relation to the guaranteed trust point, is to say that the December decision does not tell you what the Portuguese law effect is of the August decision. It is evidence of that decision, but it doesn't tell you the effect of the Portuguese law effect of the August decision. It is merely evidence of it by way of the application of guaranteed trust. As guaranteed trust says, and again, I'll make this point quickly, as guaranteed trust says, what the court has to do is treat it as evidence, but in effect what you're doing is asking yourself, what would this final Court of Appeal say would be the position in relation to the Portuguese law effect of the August decision? And if we're right, and we say on the basis of the evidence before the court, the English court, we are right, that the December decision will be overturned, then the Portuguese law effect of the August decision is as stated by the August decision, which is to say that the oak liability was transferred. Now, my learned friend, reflecting what he said in his written document, takes, I think, 3 points as to why he says the guaranteed trust point doesn't apply here. He says, first, it overlooks the fact that the December decision is binding in Portugal, and I think he says it's binding as an administrative decision. Secondly, he says that the application of the guaranteed trust point here is inconsistent with the application of Article 3, and I think he might also say it's inconsistent with Kotnik. And third, he says it's not a foregone conclusion. With respect to my learned friend, the guaranteed trust point in no way overlooks the fact that the December decision is binding in Portugal. It doesn't give rise to a res judicata. It doesn't give rise to estoppel. And exactly the same way as the guaranteed trust case itself would have been binding on the parties in New York law. Once one accepts that there is no res judicata, it simply doesn't assist to say that it's binding when the question is, how does English law establish what Portuguese law effect is given to the August decision? And again, my learned friend says, well, the problem about this is you get to a situation where the English law gives a Portuguese law effect to the August decision, which is different to the Portuguese law giving a Portuguese law effect to the August decision. With respect, that doesn't in any way take into account the fact that when in due course the December decision is overruled, it will be overruled in a way which makes it clear that the effect of the August decision is always as stated by the August decision itself, because the December decision, once overruled, will have no effect at all. Does it matter that it is an administrative decision? In our respectful submission, it makes no difference at all. In the same way as a first instance decision, once overruled, will have no effect, so that what represents the law in the foreign country will have been what is said by the final Court of Appeal. The same would be exactly true of an administrative decision. It may be binding at the moment, but once set aside, it will have been null and it will have had no effect at all. Is the guaranteed trust point inconsistent with Article 3.2? My learned friend says yes, but while saying yes, he does not say anything to the court at all about what the Advocate General in Kepler said at paragraph 72 and 73. The Advocate General in Kepler in paragraph 72 and 73 makes clear that although you have to give the resolution measure its home law effect, it is for the procedural rules of each member state to work out what that effect is. And guaranteed trust is the method by which the English court determines what effect that resolution measure has in the home state. My learned friend, whilst asserting that we are inconsistent with Article 3, does not deal with that at all. As I say, we are not the guarantee trust point is not inconsistent with Article 3 because all that guarantee trust seeks to do is to give in England the Portuguese law effect to the August decision that the Portuguese law will itself give to the August decision once the December decision is overruled. And that will always have been the Portuguese law effect of the December decision. It was also suggested by, I think, both Mr. Howard and indeed Mr. Salter that it is not a foregone conclusion that the December decision will be overruled. And there are two aspects to this. The first aspect had it that there was some relevance to the fact that Mr. Salter did not choose to challenge the evidence before the first instance court as to why the oak liability had been transferred. It was suggested that he had perfectly sensible reasons for not challenging the finding that is ultimately made by Mr. Justice Hamlin, I think between paragraphs 87 and 89, which are the paragraphs where he makes it clear we have the better of the argument that the oak liability has been transferred. With respect to my learned friend, whatever Mr. Salter's reasons were for not seeking to challenge that factual position, it's neither here nor there. The fact of the matter is that on the evidence before the English court, we do have the better of the argument that the oak liability was indeed transferred. The next way in which it is put, this point that there is no certainty that it will be that the December decision will be overruled, is by reference to a lack of evidence. Well, in opening, I gave the court the references to Moreira 1. That was to paragraph 8.4, 11.3, and 11.5. My learned friend didn't deal with that at all, but it makes it absolutely plain that where you're dealing with a situation where an administrative decision is made on the basis of a fact which turns out to be wrong, that is unlawful, and where a determination is made that that is unlawful, it will be set aside and will be annulled. My learned friend doesn't answer that at all. His only answer to that is to refer the court to Article 85.4 of the EBRD and to say, well, look, in the context of Article 85.4, it's possible for the final appellate court to make a decision which simply gives compensation. With respect to my learned friend, that is true, but utterly irrelevant. The court will have in mind that we only get into what I've called Issue 2 on the basis that the December decision is not itself a resolution measure. Article 85.4 is only dealing with challenges to the resolution measure itself. We are not challenging the resolution measure on the premise on which we get into Issue 2. December decision is not a resolution measure. Article 85.4 simply is irrelevant. I was just going to say one thing about the second part of our Issue 2 case, which is the conflation point, the Article 3 point. And the issue here as to whether there is a sufficient link as a matter of Portuguese law between the December decision and the August decision, so that one can say, as a matter of Portuguese law, that the December decision determined the effect conferred upon the August decision by Portuguese law. Now, we say no. We say that one of the problems with my learned friend's case is that it's full of assertion. They simply say that the power that was being exercised by the December decision, by the BDP in the December decision, was to implement or give effect to the August decision. With respect, there is no basis in the evidence for saying that. There is a gap in the evidence, and if one wants to identify why there is a gap in the evidence, it's absolutely plain from paragraphs 38 and 39 of Mr. Salter's skeleton argument in the Court of Appeal. I don't have time to turn that up, but I'll give the Court a reference to that now. Mr. Salter effectively said to the Court, it's SFI Appendix Part 2, Volume 1, at page 3111.
Sorry, Appendix Part 2.
Part 2, Volume 1, Tab 8, page 311.
Yeah.
3111. He said, the judge has before him expert evidence from all the parties on Portuguese administrative law, it was and is not necessary to decide any points of controversy. It is sufficient but still necessary to have regard to the context in which the subject decisions came to be made. It is sufficient for present purposes to adopt the summary of propositions assumed by the judge at paragraph 53. Now, that is what he said, and that is the basis upon which he decided to fight this case. So we never had a resolution as to whether, I apologize for the use of that word, as to whether the power that was being exercised by the BDP in December was a power to implement or to put into effect the August decision. Can I just say two other things about the conflation point, and they're these.
Well, I mean, what was it then? It's effective to determine the effect of the August decision, is the argument against you. And so it must be purporting to implement it, mustn't it?
Well, what it appears to be doing is to make a decision which is effective in itself, which expresses the BDP's view as to what was decided in August. But insofar as you're asking...
It's common ground, as I understand it, that it's binding. So for what binding. Proposition is it binding?
It is binding in terms of the proposition that the BDP has determined that there was no transfer.
No, it's
binding for the proposition that there was no transfer.
Yes.
And the question that is...
It's not just saying this is what we think.
Well, the question...
You've got to accept this.
The question that then arises is this. Are you giving effect to the December decision, or are you giving effect to the manner in which the December decision purports to implement or give effect to the August decision? And it's on that point that there is simply a gap in the evidence. Can I make this point? My learned friend Mr. Howard, and indeed Mr. Salter, when seeking to support their argument in relation to what I'm going to call the conflation points, refer the court to two things. They refer the court first to the August the 11th decision, which they say is plainly a decision intending to give effect to the 3rd of August decision. And they refer also to the decision in Kepler, and the court will recall, I think it's Law 44, 2009. There is a key difference between both the 11th of August decision and the Kepler decision and the December decision. Both Kepler and the August of the 11th decision are decisions which actually modify or amend the reorganization measure with which they're intending to deal. It's common ground that is not what the December decision was doing in relation to the August decision. So whilst it might have had an effect in Portuguese law, we say with respect that any effect it had in Portuguese law was its own effect and not an effect that it had by way of implementation of the August decision.
That's what Moreira said. They don't implement.
Subject to the court, those were the only points I was going to make by way of reply.
May it please your Lordship. Could we turn up, please, the grounds of appeal at Call 1, tab 2, page 58. It may seem a bit late to be raising the grounds, my Lord, but I just want to make a submission based upon the first of those. And it's the first ground of appeal where we've dealt with one of the two reasons given by the Court of Appeal. And your Lordship will see...
Sorry, page?
Sorry, my Lord, it's page 58, and it's paragraphs 42 to 44, to which we respectfully refer your Lordship and Ladyship. And it's the logical leap that because the December decision is the decision of an administrative authority, and for that reason directly effective in Portugal unless and until set aside, it determines how the August 2014 decision is to be applied in England pursuant to Article 3 of the Reorganisation Directive. And we set out in paragraphs 43 and 44 our complaint. And with the greatest respect, there is still no satisfactory answer from the respondents to that point. My then friend Mr. Salter conceded this afternoon that there must be some perimeter here. There must be some limit or some line of demarcation But the problem is that the respondents will not articulate, because there is not any proper justification in this case for this court to allow the August decision to be dislodged by that of December. And if Mr. Salter accepted my submission that continuity is an important purpose of the EBRRD scheme, our case doesn't depend upon some semantic or over-literal construction of the EU scheme framework. It depends upon the essential point that I made yesterday, which is that for markets to have confidence in transfers of bank business, so there isn't market meltdown, those markets must be confident that a transfer or transfers will mean what they say and will be respected by all member state courts universally throughout the Union, unless, double underline, in accordance with the EU framework, double underline, and giving effect to the transfer in the home member state court, treble underline, that transfer is to be dislodged. And that is the key point with respect on this appeal. Whenever Mr. Salter made his case effectively boils down to this astonishing proposition. He said, in support of his case, that an administrative authority can do violence to, quote unquote, a contract of the sort with which we're concerned. And so what his case boils down to is this, that every member state in the Union is obliged to recognise an act of violence to a previously transferred EU scheme contract where that violent act is A, not itself a reorganisation measure to be recognised in accordance with the EU scheme, and secondly, without there being shown any, in this case, Portuguese law basis to admit that violent act so as to disrupt or dislodge or somehow affect the previously effective scheme transfer.
Well, you say without there being shown any basis, it's common ground that a basis must exist in Portugal so that the disruption of which you complain is inherent in the Portuguese legal system. The question is whether, as you put it in your case here, whether it should be recognised in England pursuant to the directives.
Exactly, my lord. And the December decision, properly analysed, does not give effect to the August decision. It seeks to impede the August decision, but in my respectful submission, it does so, thankfully, ineffectively, as far as the EBRRD recognition scheme is concerned. And therefore, this English law contract falls to be applied in the way that we say. And just as a gas board or some decision by a Portuguese administrative authority that would otherwise bind its addressees, it's valid in that sense that it binds those addressees. But that's not the same thing as saying first that it affects the Portuguese law effect of some other decision with which we are concerned, still less that another member state court applying its law has got to give effect to that through the European scheme. And that's the absolutely key point. And the fact that the December decision purports to arrest or interfere with or tinker with, to use my Lord's expression yesterday, to tinker with the Oak contract is not the same thing, absolutely not the same thing as saying that the December decision as a matter of Portuguese law affects or qualifies or changes or any way impinges upon the effect of the August decision. That's the key point. Those are different things. The fact that you might tinker in a binding way, because that's the writ, that's how far your writ runs in terms of your admin authority powers, doesn't begin to undermine the importance, the universality, the importance of recognising universally some other decision like the August decision. You can't just slide. The claimant's, the respondent's case essentially involves collapsing the question and then asserting to this court that the December decision, because of its nature in Portugal, trumps the August decision. There's no basis for it. Mr. Salter can't identify a single specific power, either under the Portuguese banking law or the Portuguese administrative system, or anywhere in the EBRD, he can't lay his hands on a single express lever to pull. So he's fallen back essentially to an argument that says the gas board could do this, and luckily enough it was the central bank that did it, and therefore it looks quite EBRD-like. That's essentially what he says. But the key problem with that is that he does not identify, and it is not accepted on the Portuguese law expert evidence, that is what the Bank of Portugal was doing, that it was pulling a valid EBRD lever when it was issuing its December decision, valid and binding on its recipients pro tem, though it is in Portugal. And that's really what this case
is. It's not a question of Portuguese law, whether it was pulling a valid EBRD lever. It's a question of EU law for us to apply.
It is, my lord. It is. But in order for this court
to apply Portuguese law,
But, my lord, the reason it comes in is in this way, that this court is enjoined under the European law to give the August decision the effect it has in Portuguese law, and therefore we say the respondents would need to identify the Portuguese law basis. This court can't effectively make up its own view as to what Portuguese law would be, and that's what Mr. Salter's case collapses into. It really says that this court can ignore the Portuguese law evidence in this case as to the August decision, and can substitute, on the basis of assertion by Mr. Howard and Mr. Salter, what the effect, quote unquote, of the December decision is upon the August decision. That's what they say. Their case is actually the most parochial. It is, well, you can forget Portuguese law when there isn't enough there for us, and we can say to the court, well, look at December. Look what it's doing. It was the central bank. Therefore, it trumps August. That's what their case comes down to. And that is an unprincipled approach. It remains unprincipled, and it would subvert this European scheme, because it fails to respect the sanctity of the August decision, and not just this transfer, but any transfer that is done in that way. All bets would be off if you could say, trust me, I'm an admin authority. That's essentially what their case boils down to. And there must be more rigour than that. All these rules and regulations impose rigour and perimeter and analysis. And yet on the respondent's case, you put all that on one side, and you just say, well, look at December. It purported to address the oak liability, therefore this English court must respect that. And it just leaves out of account the essential crossing of the bridge to show why August should be affected in that way, given that otherwise it's common ground that August would fall to be recognised, and therefore this transfer would fall to be given effect to by this court as a matter of the European scheme and the Portuguese law effect. So it's important for this court to understand, in my respectful submission, that remains the flaw in the respondent's case. They do not begin to explain why the August decision and the sanctity of a scheme transfer is to be affected and intercepted and tinkered with simply on their assertion, that you can just look at it and read it and make up your minds.
We haven't heard very much, if anything, of what on one reading is Mr. Justice Hamlin's primary approach. He said, you take it in a temporal order. November, clear that balance of probabilities, you would have applied the August scheme and this would have been transferred. Therefore, there is something which, there's a contract with Banco Novo which contains a jurisdiction clause. That's all you need. If there's a dispute about the effect of the December decision, that's something that falls under the jurisdiction clause. We haven't heard very much of that simple argument, if anything.
Well, it's in our written case, my lord. I didn't have any time to develop it.
No, but it's still alive.
It's still a live point, and just very simply that in my submission that the continuity and the importance of the markets respecting a transfer such as this and a bridge institution rescue tool is going to be that if there is this transfer, that the contract so transferred is going to be respected. Yeah. In other words, that you get, and even with the wrinkle about the coming into effect of the changes in the European law into English law, which we deal with in footnote 24 of our written case, on Mr. Salter's case, there is still a sequence of events where you have August an August transfer followed by something happening in December. So on any view of his case, there is that we say there is at least that scintilla temporis, where we say there is accession to a jurisdiction agreement on the part of Novo Banco, and then this dispute would fall to be resolved in accordance with that if there's to be respect for the sanctity of the scheme transfer. So we do rely upon that, but I didn't have time yesterday, I'm afraid, to develop it orally. Can I just check if there are any points that I must make in the 2 minutes that are left to me? Yes. It's worth turning up Novo Banco's own experts' report, please, at core volume 4, divider 36, page 938, and looking at paragraph 9.9. 9.9, my lord. Where Professor Moreira says, halfway down, 4 lines up from the foot, reading the December decision, it is clear that BDP did not intend to alter the August decision, but only to apply it to the specific situation of the Oak liability in the light of the inquiry into the facts as undertaken by BDP. Whether or not BDP is right or wrong can only be decided by the Portuguese Administrative Court. So stopping there, we have an admission by Novo Banco's own expert that December did not intend to alter August. So we say, well, come on, court, apply August. We all know it's an EU scheme transfer, so give some effect to it, please. And then Mr. Salter says, well, hang on a minute, look at the admin decision that's binding. But it's for him to show why effectively he can take things away like that. And it's not right to say that what the central bank gives, it can just as easily take away. That's the plums and duff point. And there is a world of difference between a transfer where there's an exercise of discretion at the outset and a number of assets and liabilities are moved around specifically, one would hope with good reason, and something with which we are concerned where down the line there is an attempt to tinker with an earlier enforceable, universally recognisable EU scheme transfer. There is a world of difference.
Is the expert saying any more when he says it's clear it didn't intend to alter the August decision? Is he saying any more than standing the terms of Portuguese law, if Oak fell within the excluded liabilities, then given that the decision expressly excluded the 2% shareholder and persons acting on their behalf, all they were trying to do was give effect to the decision properly so applied legally.
Well, my lord, when your says give effect to, that's where we instantly go into the assertion and the assumption, because if you look at the appendix to my written case, your lordship will see the dispute between the experts as to all these necessary ways in which December might have been said to affect August as a matter of Portuguese law. And the way your lordship just put it to me, exactly with respect, falls into that trap. It assumes the primacy of December, rather than saying, well, as Mr. Howard accepted today, you start with August, and then you look at the effect he says that December has on it. And
if August included an illegality, that illegality would be annulled with time. I mean, if it was impossible legally to transfer the Oak liability to Novo Banco, then if nothing had been done in December, the challenge presumably could have been made on the facts that Oak liability didn't go across at all. Well, because it would fall within the excluded liability.
It wouldn't have, on that basis, my lord, it wouldn't have been transferred at all in August. But the key point is we have the better of the argument on the facts that was not the case. So this court proceeds on this jurisdiction basis that we have the better of the argument that the Oak liability was transferred, and therefore, in accordance with the August decision, satisfied that criterion and was transferred. So what the respondent's case involves is saying that that transfer should not be recognised by the English court through its universal recognition because ... And we say that what they do is just assert that's the case rather than explain why that's right.
Right.
And I can see that that's probably the end of the road, as it were.
I'm not sure it is. Yes.
My Lord, just one point that arises out of the question your Lordship asked about jurisdiction. As Mr. Lords, I think, then responded in a way that's inconsistent with the written cases. The reason jurisdiction hasn't been addressed is, at least in Mr. Rabinowitz's written case, if you go to footnote 79, it explains that if the Court of Appeal's view is right, i.e. that my submissions that they accepted, you don't ever have a jurisdiction, you never get to the question of the jurisdiction clause because NB would never have been a party to the relevant agreement. Your Lordship just want to note footnote 79 of Mr. Rabinowitz and paragraph 68.
That's why the Court of Appeal rejected the argument of Mr. Justice Hamblin.
Exactly.
There was a contract for 3 months at least, and that's enough to make the rest of it disputable.
I mean, it's because you are looking at it at the date of the issue of the writ.
That's why I didn't address it orally and my friends didn't, but what Mr. Lord, I think, said...
Your argument is that as of the date of the issue of the writ, matters are solved by the December agreement.
Exactly.
Again, I'm sorry to rise. There will be a second. My learned friend is right, but only if the court is willing to give the December decision, on the assumption we're wrong about everything else. He's right only if the court is willing to give the December decision not only effect, but retrospective effect.
Yeah.
Right.
Because if that isn't the case, then
Yes.
what we've called the relevant date point is very much a yes.
Right. The court is grateful to counsel on all sides and those who prepared the papers and will take time to consider its judgment, which will be handed down in the usual way.